Hi, everybody. My name's Karen Tereposky. I am a lawyer with Samfiru Tumarkin in the Calgary office in Alberta, and I practice in the area of employment law. And I'm here today to answer any questions that people may have about employment law or kind of the corollary subject areas to employment law, such as human rights or OH&S or those kinds of things. So hopefully we'll get some good and interesting questions today and be able to have a good discussion. So while we're waiting for some questions to pop up on my screen, usually I deal with a little bit of some areas from the news. And one thing that just recently came up in the news is some more job cuts at the CRA. It looks like in addition to some jobs that were lost, about 450 jobs that were lost, I believe, last month, CRA is looking to not renew over 1,000 contracts, I believe, of their employees. So a lot of people working for the CRA losing their jobs. And it's not clear if those are going to affect unionized and non-unionized employees, but from a non-unionized perspective, which is what we deal with at Samfiru Tumarkin, people should know that when they lose their jobs, even if it's as a result of restructuring or a downsizing or whatever, they are entitled to their rights under the employment laws, including a full severance. So, depending on your length of employment, age, your position, availability of similar employment factors like that, severance packages can range, from up to 24 months. A really good way to find out, what you might be entitled to if you are losing your position is to use our employment law, our pocket employment lawyer, which is a severance calculator. And what you do there is you put in some of your factors, like the ones I just mentioned, like age and years of service and those kinds of things. And it will tell you sort of what you might be able to expect in terms of severance being awarded by a court if you had to go that route, and what possibly your employer should be offering you at the time of termination. And if your offer isn't anywhere near what that calculator is saying, it would be a good idea to get it reviewed by an employment lawyer at Samfiru Tumarkin. We can go over the circumstances with you and let you know if we think that you're entitled to more and whether it's worth pursuing. So I see we do have a couple questions coming in. The first one is from Reddit, and it says, I was recently terminated from my role as a development manager. They said I didn't follow protocol for an information request. I was not spoken to about any of this, just let go, and I feel it was a misunderstanding. What should I expect now? I haven't received anything further after being told I was let go verbally. Okay, well, that sounds like if they've just said you're being let go and they haven't given you any sort of offer of a severance package or anything like that, it sounds like they are using that incident to support a termination for just cause. It sounds that way anyway. There may still be a written termination letter coming, but it does sound like they're trying to say that there's been just cause for termination, which wouldn't entitle you to any severance. It is a bit unusual for sure for employers to be able to prove that one incident in an employment relationship is enough for a just cause termination, which disentitles you to any type of severance. You can't get EI, things like that, when you're terminated for just cause. So it's what we call sort of the capital punishment of employment law, and it's reserved for really the worst types of misconduct. So when there's just one incident, that is, it is very tough for an employer to prove just cause. So it may very well be that if you are terminated or have been terminated for just cause and not getting any offer of a severance package, that we could push back on that and we could, try get you a actual severance, given that the employer runs a pretty substantial risk that they're not going to be able to establish just cause. I'm assuming you never really got into it, but that, there weren't prior incidents, because obviously if there were prior incidents or you were disciplined about other things that are sort of on the same line of behavior, they may have a better case for a just cause dismissal. So, get that looked at by an employment lawyer, and maybe we can help you get something out of some severance in that situation. So another question coming in from YouTube. I've been off on disability for the last 4 years. My employer recently called to tell me they were letting me go from the position. Am I owed any severance in this situation? So that's an interesting question, and we deal with that a lot, where an employer decides that basically the employment contract has been frustrated by your not returning to the workplace for an extended period of time. However, the test for frustration of an employment contract isn't necessarily just a time thing. It's not, you haven't been back for 4 years, so the employment contract's been frustrated. So I'm just going to plug in my computer here because it's telling me it's slow. So with a frustration of contract, you would not be entitled to any severance if the contract is truly frustrated, and that's in Alberta. There is no severance owing under frustration of contract if it truly is frustration. The test, though, for frustration of contract is that the employee will be unable to return in the reasonably foreseeable future. So it's not just about how long that you've been out. So unless there's medical that has said that there's no prospect of a return or something to that effect, the employer might have difficulty proving that there's been frustration of contract. If you do have some medical that says you may return in the next little bit, you'll have a good chance of proving that the contract hasn't been frustrated, in which case you would be entitled to severance. So pending some other details on your situation, I think there's a chance that you could be entitled to severance if the contract hasn't truly been legally frustrated. I have another question from Samuel, looks like. I just signed on for a seasonal position and was contracted to do the next 5 months, but my employer said they lost a client and now don't need me. Have I already signed? Am I owed anything? You may be, depending on what kind of contract you signed. If you signed a 5-month fixed term contract, and everything was signed up and was ready to go, it's possible under a fixed term contract that you may be entitled to be paid out for that contract if they just terminated it and there was no early termination provision. The employer may be able to argue again, like that contract has been frustrated because they can't provide the employment, but it will depend on the terms of the contract. So my suggestion to you would be to get that contract reviewed by an employment lawyer. If it is truly a fixed term contract that's been entered into, there's no early termination provision, you may be entitled to be paid out for the contract. If it's a seasonal position, generally, seasonal work is not protected under the Employment Standards Code in terms of minimum termination pay. So that piece is potentially not available to you, but you may be entitled to compensation under the terms of a fixed term contract, depending on the wording. So that would be the route I would suggest for you. I have another question coming in from YouTube. My wife was let go from the bank 5 years ago. She was harassed by her employer until she signed the release. Is there anything she can do about this now? So if it was 5 years ago, we get into the issue of the limitation period. And generally, limitation periods are 2 years for wrongful dismissal action and 1 year for a human rights complaint. So you're likely out of time. Unfortunately, if you wait too long to bring these types of actions to the courts or to a tribunal, they don't have jurisdiction to consider them, because under statute, it actually says that they can't consider anything that was more than a certain amount of time ago. And it's not something that's even in their discretion to look at and go, well, in this case, we'll consider it. It's just statute barred, it's called. So as far as a wrongful dismissal action, 2 years from the date of termination. For a human rights complaint, it would be 1 year from discrimination. So I would think if it was 5 years ago, it is unlikely that you would be able to do anything about it now. You just waited a bit too long. So I have another question coming in from Facebook. I've maintained a permanent work from home arrangement since COVID, March 17th, 2020. As explicitly stated in my contract, with an amendment that allows for a recall if needed. Given that I have effectively been working remotely for 5 years, it stands to reason that my primary place of work has become my home. Considering my 7 years of service with this corporation, any significant adverse action taken against me for refusing to return to the office could potentially be challenged as a constructive dismissal. Okay, well, that's more of a statement than a question. I'm not sure what you're asking there. I guess, your opinion there, it's possible. I would have to know more about what it says in the contract. If there is a provision that says, and that you've agreed to, and that it's been validly put into a contract, that there's an amendment that allows for a recall if needed, and that's been agreed to. It may be that that's part of your contract as well. So, it could be that, work from home is part of your contract, but if there's also a provision in there that you've agreed to validly that says they can recall you, it may not be a constructive dismissal. Most of the cases where there is a recall to work from a work from home position, the courts have kind of sided with the employer on their discretion to be able to recall. If it does say in someone's contract that they are allowed to work from home, or part of the contract is that they do work from home, then yes, just changing it would be, a unilateral change to a term of the contract, and would lead to a constructive dismissal. But if there is a term in there that says, you can be recalled if the employer views it as necessary, that may change that. So we would have to review the contract itself to be able to really give an opinion on that. But the opinion that you've, I guess, put forward, it doesn't look like a question, it looks like more of an opinion, could be true depending on the wording of the contract. So I have another question coming in, and it says, my employer is changing our location of operations. This is going to result in an extra 1.5 hours of commute time, and I don't think I can manage this. If I quit, can I still claim EI? So if you resign from your employment, you generally cannot claim EI. They will refuse you on the grounds that basically you should have stayed working. You could potentially, I think, there's an argument there that I guess, again, it's one of these situations where, is this a unilateral material change to the terms of your employment contract, right? So, if they're moving their operations an hour and a half away from you, was your employment contract based on a closer location? And is this a material change that's been unilaterally imposed on you? So, if that's the case, and it sounds like it may be, there's potential to argue that you're being constructively dismissed. So you could resign on the basis of a constructive dismissal. Whether EI would allow you to obtain benefits, I can't really give an opinion on that. We're not really EI experts. It's kind of a peripheral area to employment law. We kind of know what to do as far as applying, but EDSC or ESDC Canada is a little bit of its own animal, and they do things that are a little bit unpredictable. So, if you do resign and say, I'm resigning on the basis of a constructive dismissal, and tell Service Canada that, there's a possibility you might be approved for EI. Sometimes what happens is they go back to the employer and they ask about, why the ROE was issued. And if the employer doesn't even respond, I've had clients that get EI, even in a just cause termination situation. So I can't guarantee that, you would get EI. If you just resign, unlikely. If you resign on the basis of a constructive dismissal, maybe. But if you do resign on the basis of a constructive dismissal, what you more likely could be entitled to is severance. And that's obviously, could be more than EI. So what I would recommend is that you do reach out to someone at our firm and, have a consultation, and, one of our lawyers can look at your situation and find out, whether or not it makes sense to guide you through that constructive dismissal process, because resigning on the basis of a constructive dismissal can, there's a little bit of wordsmithing that has to happen when you're doing that resignation. So it's worthwhile to have someone in your corner advising you on that. So moving on, I have another one from YouTube. My partner just gave her employer a heads up that she is going to be going off on maternity leave in the coming months. Suddenly, it seems like they have a number of complaints about her work. Before this, she received a lot of positive feedback. good annual reviews. Is this them trying to fire her for her upcoming leave? Well, I mean, maybe I would recommend that your partner keeps track of everything, takes good notes, documents everything that's going on, the timing. Um, I don't know if she's being necessarily disciplined according to what you're saying, or if they're just, like you said, they have a number of complaints about her work. Generally, if they're trying to terminate for just cause based on performance concerns, there needs to be quite a significant process. Basically performance management. So if they have complaints about work, they usually have to say, we have these complaints, this is what you need to fix, this is the standard that we need you to get to, and here's the amount of time you have to do it. We're going to check in with you along the way, and we're going to try to help you get there. And then if you don't, maybe you're going to get terminated for cause. So if it's work or complaints about performance, it does have to be managed pretty closely by the employer to get there. And obviously, if there is a termination, during leave, that's a violation of employment standards. If it's even when she comes back, it could be, a human rights violation. So there's a lot of recourse if that does happen, or potential recourse. I really can't say whether or not, this is what the employer is trying to do. It may be they have to do it properly for it to be successful. So if something does happen, if there is a termination, I would say reach out to the firm, to Samfiru Tumarkin, and, get someone to go through the details of what happened. It's possible that there might be severance owing, there might be a violation of employment standards code, and there could be a human rights violation as well. So, really important to sort of have someone help you manage that situation, I would say. Okay, next one from Reddit. I'm currently in my probation period, but will have to take a medical leave. Can my employment let me go for this? Well, so letting someone go during a probationary period, 3 months or 90 days, actually, under the Alberta Employment Standards Code, that just means that there's no minimum statutory amount owing under the Employment Standards Code. So minimum amounts of termination pay, after 90 days up to 2 years is a week, right? So that's all it is. It's just 1 week of termination pay. And if you're let go in that 90 days, you're not entitled to termination pay. That does not necessarily mean you're not entitled to common law severance, or that higher amount of severance that really is what we look at Samfiru Tumarkin. And if you want to find out what that could possibly be, what you can do is look at our pocket employment calculator. Which we have online, or Pocket Employment Lawyer, sorry. It's the severance calculator, and you can look at that and find out what you might be owed. And it will depend. Obviously, you're in a shorter. Your term of service is quite short, but it depends on age, depends on your position. And there has been case law. There was a case out of BC, I think last year, 2024, where somebody worked for 3 days and the court awarded them 3 months severance. So, it may be that, it's possible that you could be owed some severance there. Also, if you're saying you're going to take a medical leave and they terminate you because of that, it doesn't matter if you're on probation or not. The protections of the Human Rights Act still apply to you, even if you're during a probationary period, even if you just started. So if the actual reason for the termination is the medical leave and it's linked to a disability, then it's a human rights violation. So, you could be entitled to lost wages, you could be entitled to general damages related to that violation of the of the Human Rights Act. So, can your employer let you go for taking a medical leave? Not legally. If they do, you could have some recourse if it's based on a disability. If that's even a percentage of the reason why they let you go, that's actionable. So, if that does happen, if you have to take a medical leave and they decide that they're going to terminate you, reach out and talk to somebody at the firm. Some employers don't realize that there's other, that there are other protections in place outside of just those termination pay pieces in the Employment Standards Code. So yeah, I would look to see what happens. They can't terminate you legally, I guess guess short answer to your question. It's not a legal termination if they terminate you for taking a medical leave. It would be a violation of human rights, likely. So I think follow-up question here from Stan. So I just keep working until I can possibly claim a constructive dismissal. If I start working at the new location, would this hurt my chances? Yeah, it definitely would. So part of the concept of a constructive dismissal, or not part of the concept, but a defense to constructive dismissal on the part of the employer is condonation. So if they make a unilateral material change to the terms of your employment contract and you condone that change. So if their change is they've changed your job location, it's really far away, you consider that a unilateral change to the terms of your contract. But then you decide to go work there. Now you've condoned that change. And you have to be careful with that, because if you condone the change, then the employer can say, well, the employee condoned it and there's no constructive dismissal here. What you can do is you can say, I believe I'm objecting to this change. I believe I've been constructively dismissed because this is a unilateral change to the terms of my contract. It's a material term of my contract. I'm objecting. Then you say, but I will continue to work because I want to mitigate my damages. Basically, you're saying, you've caused me damages. I've lost my job, really, but I can't find another one. So I'm going to keep working just to make money for now. So if you do that, you may preserve your right to claim constructive dismissal later on. But you do have to be really careful with it. And like I said before, that there is, you have to be careful with your words. You don't want to resign. You don't want to condone the change. So, I would recommend that you talk to somebody and get some help. In a lot of situations, what we do when we have a constructive dismissal situation is we'll ghostwrite emails for people, and then they send that to their employer. So you can get some help with that. I would reach out, because you don't want to sort of accidentally do away with your ability to claim constructive dismissal. Okay, so another one here. I was terminated without cause after 27 years of employment. I signed an employment agreement that limited severance to 6 months. Am I limited to this amount? I'm 60 years old now and limited job. I think there's maybe more to this, but I might have just sort of cut off. Anyway, based on the facts there, employment agreements often try to limit your rights on termination. There's a lot of reasons, though, why we often are able to argue that those employment agreements either are not enforceable, don't apply, or they're illegal. So I would get that reviewed. At 60 years old, after 27 years of employment, under the common law, your severance could be about 2 years. So it's worthwhile to get someone to look at that employment agreement and let you know, is this 6 months really what you're limited to? There's a lot of reasons why sometimes those clauses are not properly drafted. Sometimes the employment agreement is, just invalid on its own, and you didn't get any benefit for signing it. Sometimes you're there 27 years, they give you an employment agreement after 10 years and say, well, you have to sign this. Well, if you didn't get a raise or a bonus in conjunction with that agreement, it's not even binding. So get someone to look at it. You may not be limited to that amount, I guess, is really the bottom line here. Reach out to our firm. We do that all the time. I probably argue about termination clauses in employment contracts, as 50% of my practice. So get it looked at. I have another question coming in from YouTube. I was with my company for maybe 5 months. I would start at 2 to 3 a.m. as a truck driver. My issue was last week due to insomnia issues. I was late all week. I really didn't mean it. It's performance in their eyes. This is not a new issue for me. And my coworker was talking crazy and getting out of line. Should I leave it alone, or I didn't get dismissal papers? Neither. Well, so I guess it sounds like you were just terminated, probably for cause based on performance, because you're showing up late for work. My question would be, with the insomnia, do you have any sort of diagnosis or medical history or medical records that would indicate that this is related to some sort of disability? Because if there is an issue, like say you're on medication, or there's some kind of diagnosis that leads to insomnia, it's possible that that's a disability. And then if they're terminating you based on behavior that's related to your disability, then that's a human rights violation. I think if you're late all week and they are, writing you up and warning you and saying, well, if you're late one more time, you're going to get dismissed for cause. There's potential there that they could actually establish that it was a just cause termination, but we need to know, I guess, how it led to that. Is it one incident where they, wrote you up and then there was another one and then they wrote you up again? Or is it just like the last time they didn't warn you and then the last time they just said you're fired for cause? So it's a lot of, there's a lot of factors that go into it. I'd reach out to the firm, reach out to Samfiru Tumarkin, get someone to assess your matter and see if it's worth pursuing. Just because you talk to a lawyer doesn't mean you have to sue. So, it's worthwhile to get some advice on that. Next question from YouTube. Can you be fired for living your life after hours? Say your employer disagrees with your hobbies or opinions or something. Can they just let you go? So there is case law. There has been precedent on employees that are fired for off-duty behavior. It does depend on a lot of things, as most things in the legal world do. So it depends what that behavior is, if it's connected to your work at all. Sometimes it's social media presence. If it's something that affects the employer's reputation in a negative way. The example and kind of the one of the first cases on this issue was, I believe, a firefighter in Toronto who he had a bunch of things on his Twitter, or X it's called now, it was Twitter at the time. And a lot of it was very, controversial. And in his profile picture, he was wearing his, Toronto Fire Department or whatever it's called, clothes, like uniform. So the employer took the position that, he was representing the employer, and that one was upheld, that was a viable reason to say that there was a just cause termination. So it depends on a lot of things. You can go, live your life, as you've said, but, you have to be careful that it's not reflecting on your employer. So depends, but there is precedent for off-duty behavior giving rise to a just cause dismissal. It just kind of depends what it is. Okay, so I guess some follow-up from the insomnia issue. The employee does take medication, has for years. And is used to a 6 a.m. job at a previous start as well. Yeah, I mean, if there's some connection to a disability, there's definitely potential for a human rights complaint there. So, have that looked at. Question on YouTube from Anita. What can you do if your employer starts suggesting it's time for you to retire? Are they allowed to change your job duties because of this? That's a really, really slippery slope for an employer. Suggesting that an employee retire and then definitely starting to change your duties, that's discrimination based on age. So that's a problem. That, again, is a human rights issue. Under the Human Rights Act, there are particular enumerated grounds that are protected from discrimination in employment practices. One of those is age. Some of the other ones are disability. We've already talked about a bit today. Gender, race. Gender is the one that goes to the maternity leave that we referred to earlier. So, a lot of times I have people who get asked a whole bunch of times, are you going to retire? Are you going to retire? Are you going to retire? And then they get let go. And, what we argue is part of the termination is based on age. And then we also submit, human rights complaint. And, there can be, additional sort of damages, I guess, that can be claimed under human rights as opposed to just a wrongful dismissal action, because it's discrimination. So there's different kinds of remedies in play. So, basically, I guess the answer to your question is, what can you do? I guess definitely document it. Every time that question comes up, write it down, keep a journal. This is what happened. This is who said it. This is what time it happened. If it's in an email, take a picture of that email, because if you do get terminated, you're going to lose access to your system immediately. Make sure you're keeping good track. And then if you do get terminated, that age discrimination piece, or if they're changing your duties, that's, something that should be looked at. As I said, we do human rights law at Samfiru Tumarkin, and we can help you with that if you reach out. So another question, just have a minute or so left. Is arbitration good for employees? Arbitration can be, it can be quicker than the courts. So, I mean, it kind of, again, depends on the situation. Sometimes some arbitrators are super expensive though, so that can be a real problem for employees because, if they're supposed to split the cost of arbitration with an employer, it can be, cost prohibitive. And there is actually a pretty big case that our firm, Mr. Samfiru, our founding partner, won at the Supreme Court of Canada, that has to do with an arbitration clause being basically unconscionable because it was too burdensome on the employee. So it can be good because it can be quicker, but it can be really expensive. So, is it good for an employee? Depends on the situation. Last question, I guess, because we're at 9:30. What happens if the supervisor who fired you with discrimination is fired for other allegations? Supervisor who fired you with discriminations. I mean, it doesn't really matter if the person who fired you is fired for something else. Your action is against your employer. So, it's against the employer in general, not a particular employee who happens to be in a supervisory or management position. So you would still have a claim for a human rights violation if there was discrimination in your termination. I hope I'm answering that question properly. I'm a little bit confused by how it's written, but I think I've got to what you're asking there. So hopefully that answers that question. Hopefully I've answered everybody else's questions as well. Thanks a lot for joining today. We really appreciate all your questions, and it's always helpful to get the information out there. Of course, join us again for our employment law Q&As. Next one tomorrow. See it on your screen there with Leo or Samfiru at 1 p.m. Eastern time. Hope everybody has a good day and have some more questions for me next time. Thanks for joining us. Take care.